Welcome everyone to today's webinar on demystifying the re-parole application process for certain Afghans. We're going to give everyone about 30 seconds to join, so we'll start in about 30 seconds. Again, welcome everyone to today's webinar. We're going to be covering demystifying the re-parole application process for certain Afghans. So thank you again for joining, and today's training is presented to you by Switchboard. Switchboard is a one-stop resource hub for refugee service providers in the United States. As we get started, we just want to go over some Zoom webinar quick tips so that we're all comfortable here today. Due to the large number of learners on today's webinar, we've disabled the chat box. However, you do have the option to send messages to the speakers and co-facilitators via the Q&A. Please remember to only submit questions related to today's topic of re-parole, and be sure to respect client anonymity, and avoid case-specific questions. Keep an eye out in the chat for messages from Switchboard for links to various resources that we'll be mentioning. And today's webinar will run for about 90 minutes, and it is being recorded. You'll receive an email with the recording, slides, and recommended resources within 24 hours. The webinar transcript, along with the recording, will be posted on the Switchboard website within the following days. And then lastly, we ask that you kindly complete our webinar satisfaction survey at the conclusion of our session. This short 3-question survey helps us here at Switchboard continuously improve our training and technical assistance offerings to you all. And with that, I'd like to introduce today's speakers. First is me, Ashley Digiore. I'm a contract project manager and accredited representative with VECINA's partnership with Switchboard. I began my career as a teacher and have since explored my passion for supporting immigrants in my community, which led to the development of an immigration legal services program and becoming a DOJ accredited representative in 2022. I have volunteered with VECINA since 2021 and have enjoyed helping immigrants throughout the United States as well as those in my community. Our next presenter is Michelle Morales, and she's a contract mentoring attorney with VECINA Switchboard Partnership. She runs a solo immigration practice in Silver Spring, Maryland, and is an adjunct professor at the George Washington University Law School, where she teaches immigration law. Before starting her practice, she worked at U.S. Citizenship and Immigration Services as an asylum officer, refugee officer, and trainer. She has worked in the nonprofit sector at AYUDA in Washington, D.C., and the Central American Legal Assistance in Brooklyn, New York. And our last presenter is Kristen Nilsen. She is a contract mentoring attorney with VECINA as well. She has more than 10 years of experience in U.S. immigration law. She has worked in private practice, at nonprofit organizations, and also at U.S. Citizenship and Immigration Services as an adjudicator. Her background gives her unique insights into the immigration process and a deeper understanding of all types of immigration cases. She is dedicated to protecting the rights of immigrants and their U.S. citizen families. Now that you know us, we'd like to get to know you a little bit. We have a question on the screen. Based on your current experience, how confident do you feel preparing and filing an Afghan re-parole application? So if you would grab your phones and scan that QR code by opening the camera button, hover it over the QR code, and it will pop up with the Slido, or you can type in the website, slido.com, and enter that code on the screen to let us know, based on your current experience, do you feel a 1, not very confident, a 5, super confident, or somewhere in between when filing a Afghan re-parole application? Got a few people answering, not a lot, but it looks like our average score is about a 2.7. So that is perfectly fine. That's why we are here today, to help you hopefully move a little closer towards that 5. And now I will turn it over to Michelle.
Good afternoon. Yeah, based on the poll, this is a perfect time to let you know that we recognize that the level of experience you all have in filing immigration benefits for clients varies. So the presentation part of the webinar is aimed at those with less experience. You can sort of think of it as Re-Parole 101. And we're reserving a lot of time for Q&A at the end. And it's at this time that we welcome participation and information from audience members with more experience preparing and filing applications with USCIS. So for the learning objectives, this is what we hope you'll take away from today's webinar. By the end of the webinar, you will be able to explain to potential clients who qualifies for Re-Parole, describe to them why Re-Parole is important, and address common filing concerns. This webinar will provide practical guidance and information that is as up-to-date as possible as of today, July 19th, 2023. So let's begin. I'm sorry, on the previous slide, who qualifies for Afghan Re-Parole? And on the next slide, we have those who qualify are, and I'll let you take a quick look at the slide, and then I'll give you some notes as you're reading. So it's certain Afghans already paroled into the United States under the class of admission OAR or PAR. Another way to think of it is Afghan nationals present in the United States who were not paroled in OAR or PAR status are not eligible for Re-Parole. Now, the time frame to apply for Re-Parole does not end until next year, July 31st, 2024. But please be sure to prioritize clients in order of when their parole expires. And this can be found on the client's I-94. So apply as soon as possible. Clients with pending asylum or adjustment of status applications do not need to apply for Re-Parole. They will be considered on a case-by-case basis for extension of their initial period of parole. And it's a distinction. It's important to remember that this extension is separate from the streamlined Re-Parole application process. And one big note we'd like to make, if the applicant has been charged with, convicted of, or even just arrested for a crime, or had any contact with law enforcement, they should consult with an immigration lawyer experienced in criminal immigration issues before applying for Re-Parole. Here are some examples of scenarios you might come across with potential clients. And I will read all three aloud and pause for you to determine if they are eligible to and should apply for Re-Parole, and then let you place your answers in the Slido. So we'll keep this slide up for now, and I'll just read it out loud as well. Scenario number 1. Ashmal was paroled into the United States in November 2021 as an AOR parolee. He contacted his local resettlement agency and requested help to apply for asylum. He was added to their wait list, but has not yet received a call back. Scenario number 3, Farah. She arrived at the San Ysidro, California border checkpoint in December 2021 and was found to have a credible fear of persecution. She worked with a private attorney to file an asylum application before the immigration court. She is still awaiting her hearing. Scenario number 3, Shah. He was paroled into the United States in September 2021 with PAR status. He worked with a nonprofit to file his asylum application in September 2022. He is awaiting adjudication. Go ahead and put your answers in. Who do you think should apply for re-parole right now? And you can choose as many as you want. Okay, I'm going to go ahead and read the answers. So we have 89% of you are correct with scenario number 1. Yes, Ajmal is the perfect example of who qualifies to apply for re-parole and should apply now. Now, scenario number 2, the answer is no. Farah does not qualify for re-parole or extension of parole because she is not an OAR parolee. And scenario number 3 is also no. Shah should not apply for re-parole because USCIS will undertake review of his case to determine whether to extend his parole without the need to submit the I-131 under the streamlined process. So next topic, why is Afghan re-parole important? Re-parole is a new period of parole under the streamlined process. So USCIS can grant re-parole for up to 2 years. If parole expires, remember the applicant will no longer be in a period of authorized stay unless they obtain another immigration benefit. Afghan parolees can request employment authorization when they apply for re-parole. If the re-parole request is approved, employment authorization will be granted for the same period as the new parole period. Re-parole extends eligibility for the asylum 1-year filing deadline exception. And it may extend eligibility for mainstream public benefits, resettlement assistance, and other benefits available for refugees. Keep in mind that re-parole is temporary. It's a temporary immigration status. It is not permanent. So be sure to screen clients to see if they are eligible for another immigration benefit that leads to permanent status. And I'm passing over to you, Kristen.
All right, thank you, Michelle. In this section, we're going to cover the common concerns that preparers have been asking about filing for re-parole. We will be addressing the most common concerns during this part of the webinar, and at the end of this section, we will open the floor to additional questions you may have. Please know that this is not a comprehensive overview of the filing process. If you would like a step-by-step guide, there's an e-learning course on Afghan re-parole on the Switchboard website and on the VECINA website that goes over the process in greater detail. It provides resources that you can go back to and refer to both on video and on paper. On to the next slide. So here are some questions that you may have before you start an application for re-parole. If it's called Afghan re-parole, why am I filling out a form called an application for a travel document? Should I apply online or submit a paper I-131 application? And why does everyone need their own email address, even children? On the next slide, we'll see that we will begin with the form I-131 itself. The form is called an application for travel document. Why are we using this form for re-parole? The simple explanation is that USCIS did not create a new form for Afghan re-parole. If USCIS had created a new form, it would have further delayed implementation of this re-parole process. Instead, USCIS modified the existing form I-131, application for travel document. The I-131 is already used for other types of parole, such as advanced parole, humanitarian parole. So it made sense to adapt the form for Afghan re-parole. On the next slide. The next common question is whether it is better to apply online through my USCIS online account or to mail in a paper application. USCIS encourages all applicants to file their applications for Re-Parole online through a myuscis.gov account due to the many benefits offered through an online account. For example, when you file a form online through the USCIS account, you will get immediate confirmation that USCIS has received your application, and you will receive your receipt number. You can also view evidence that you have submitted to USCIS through your USCIS account. You will have the ability to check case status and sign up for notifications, respond to requests for evidence, send secure messages, and update your address, and access case details anytime from any device. USCIS has also published videos on how to create a USCIS online account in Dari and Pashto and how to navigate the streamlined online application. That being said, you can file a paper I-131. In some cases, that may be the better option for your client, particularly if they are not comfortable with technology. Clients are required to have their own myUSCIS accounts and email addresses to participate in the online filing process, and that may be a barrier for some people. If you are unable to help them access a myUSCIS account, review the draft application, or accept and sign the application, you may prefer to fill out a paper application. On the next slide, why does everyone need their own email address in myUSCIS account, even children? USCIS has created a streamlined process intended to be easy for applicants to complete on their own. So one unique account per person helps USCIS quickly review each application. Parents can create email addresses and USCIS online accounts for their children. Preparers can also help parents create email addresses and USCIS online accounts for their children and for the parents themselves if they need that help. Parents can sign and submit the applications for children under the age of 14, but children over the age of 14 should sign and submit their own applications. And on the next slide.
So now we're going to take a look at some common concerns when completing the form I-131. These questions include: what boxes should I check to ensure an application is processed correctly as a re-parole application? How should I answer the application questions about advanced parole? What do I need to submit with a re-parole application? And what is the role of the preparer? And I just wanted to throw out a reminder that if you have questions, you can type them in the Q&A, and we can save any that we can't answer for our question and answer time.
Thank you, Ashley. So moving back to the questions. The most important thing to keep in mind is that while re-parole is a legal process, it's not legally complex. Many of us have likely filled out an I-131 at one time or another. The form itself is simple. The key, however, is checking the correct boxes to ensure that the application is processed as a re-parole application. So what boxes should you check to ensure the application is processed as a re-parole application? The most important question on the online application are under the section Getting Started / Basis of Eligibility. There you will see 3 questions. The first questions ask what type of application you're applying for. You must choose the answer, I am outside the United States and I'm applying for an advanced parole document. Yes, you will choose that answer, that the applicant is outside the United States and that they're applying for advanced parole, even though neither is true. The answer mainly helps USCIS identify that the applicant is applying for him or herself and not for a third person. And it also ensures that the application is identified as exempt from a filing fee. It is important to note that even though you are checking a box saying you're applying for an advanced parole document, the applicant will not receive an advanced parole document or any other type of travel authorization. Re-parole approval does not grant the applicant the right to travel outside the United States. For those filing paper forms, this information corresponds to page 2, part 2, option 1E. And on the next slide, what boxes should I check for a re-parole application? Are you asking for expedited processing? You should check no to this question, as all re-parole applications will generally be subject to expedited processing under the streamlined application process for eligible Afghan nationals. You don't have to affirmatively request that. And then the third and most important question is, are you applying for re-parole? And this answer will always be yes. For those filing paper forms, you will not see these two questions about expedited processing and are you applying for re-parole. Instead, at the very top of the form, you should write re-parole on the top of page 1 of the application. And we recommend that you write it in large print and highlight the word re-parole to ensure that it's processed correctly. And the next big question is, how should I answer questions about advanced parole on the application? Remember, the I-131 is used for many different types of immigration benefits. Your applicant is not applying for advanced parole, so these questions do not apply. You can either type NA on the form or leave it blank. The online filing system allows you to do either. This part corresponds to parts 4 through 7 on the paper I-131 application, which reference advanced parole, refugee travel documents, and the like. Your applicant is not applying for any of these types of documents, so you can either write NA or leave the form blank. On to the next slide. What documents do I need to submit with the I-131? After completing the form, the online system will allow you to upload documents in support of the re-parole application. The only required documents, other than the form I-131 itself, are a clear copy of a government-issued photo ID and a preparer's declaration if a preparer has completed the form for the applicant. You will not submit a filing fee. The application is free. You do not need to upload or submit passport-style photos. You do not need to upload or submit proof of current parole status. You do not need to submit any documents regarding urgent humanitarian need, and it is not applicable here. And finally, you do not need to file a separate I-765 application for employment authorization. Applicants will automatically receive a new card if you choose the option to receive a new EAD on the form. You can find that option at the bottom of the other information section of the About You section of the online application and on page 4, part 8 of the paper application. So we'd now like to open the floor to your thoughts on what would be an appropriate document to submit as photo ID. We are going to generate a word cloud here based on your responses. Please type your answers using Slido. You'll see this on the next slide. More than one answer is correct, so please share your thoughts. Right, thank you, everybody. As you can see there, the middle word EAD is the most popular answer, and then you'll see in decreasing size what other people have answered. Our recommendation is that their current C11 parole EAD is probably the best photo ID to submit. You can also submit driver's licenses, passport biographic pages, state IDs, and other type of EADs in other categories. In some cases, especially for children, if they don't have any of those, you may be able to submit a school ID, especially if they have a photo on them. It's not the best, but if that's what you have, that's what you can submit. So on to the next slide. What is the role of the preparer? The preparer is you. If you are helping an applicant complete an I-131, you are the preparer. The preparer can be an attorney, an accredited representative, or any person who helps the applicant fill out the form. It could be a friend, a neighbor, anybody who's helping them complete the form in any way. If you are helping your applicant to file online, you will need to download, fill out, sign, and then upload a preparer's statement. There's an example here on the screen. If you're filing a paper application, you will complete and sign part 10 on page 5. Note that if you're an attorney or accredited representative, you should also complete a G28. The preparer statement alone is not enough to establish that you are representing the applicant on the application. On to the next slide.
Okay, so some additional comment questions. What will the applicant and I receive after filing the application? Where can I find documents after submitting the application online? And how will Afghans with pending asylum or adjustment of status applications know whether they have received an extension of their initial parole period?
Next slide. What will the applicant and I receive after we submit the application? If filing online, you will see receipt notice right away. Usually, if it's not there automatically, it will be there within about 2 to 3 hours. USCIS will also mail you a paper copy of the receipt notice. And they'll send that both to the applicant and to the attorney or accredited rep of record. They will not send it to the preparer unless there's a G28 on file. If your applicant needs new biometrics, you will receive an ASC appointment notice, both online and by mail. If your client does not need new biometrics, you will receive a notice that USCIS will reuse previously captured biometrics. If USCIS requires more information, you may receive a request for evidence both online and by mail. Once approved, you should receive an approval notice both online and by mail. The approval notice may contain language authorizing the extension, or you may receive a separate notice authorizing the extension. If it's denied, of course, you will receive a denial notice online or by mail. If you've checked the box requesting a new EAD, your client should receive a new physical C11 EAD card. Your applicant's I-94 should also be updated by CBP, which can be accessed on the CBP website. Just as a reminder again, USCIS only issues copies of correspondence to attorneys or accredited representatives who submit a completed Form G28, Notice of Entry of Appearance as Attorney or Accredited Representative. On the next slide. Where can I find these documents after submitting a case online? Navigate to your applicant's name and click on I-131. Under the drop-down menu at the top of View PDF, you will find a copy of the I-131 and a G28 if filed. Under the tab Notices, you will find a copy of any notice sent by USCIS, receipt, biometrics, RFEs, approvals, etc. And then on to the next slide. We wanted to address this even though Afghans with pending asylum or adjustment applications are not part of the re-parole process. We wanted to let you know how they would know that their period of parole has been extended. Just as a reminder, they should not file for a re-parole at this time. They will be considered on a case-by-case basis for extension of their initial period of parole. This extension is separate from the re-parole application process. USCIS has stated that a Form I-797C will be sent to their last address of record. This notice will extend their current parole status and their current employment authorization. If these clients want a new EAD card, they will then need to file an I-765 for no fee under category C11. They will not automatically receive a new card like re-parole applicants. It's very important to make sure that if the person has moved since filing for asylum or adjustment, they file a change of address, AR11, online. USCIS has also indicated that changing their address on their My USCIS account profile will suffice as an address change. And on to the next slide.
My apologies. Thank you so much, Kristen. So now that we've gone through who qualifies for a re-parole and some of those big questions that have been out circling among us, helping those filing, we wanted to open the floor for questions and answers. We have a few questions in the chat that we will get to. To start us off, we'll start with this question. My client has asylum pending. He has not received notice that his parole has been extended. May I help him apply for a re-parole? So Michelle, would you like to answer that?
Sure. Yeah, this is a very common question right now. And essentially, what you're going to have to do, although USCIS has confirmed that they're working as fast as possible to avoid any lapses in parole, you are ultimately going to have to balance being an advocate for your client with not overwhelming USCIS with a flood of applications they don't have the resources to handle. And it's just a call you're going to have to make. A lot of these deadlines are almost upon us, but that's, the guidance from USCIS still today is to not file an I-131 for Afghan nationals who have asylum or adjustment pending.
Thank you, Michelle. In the chat, we did have a question concerning pending adjustment of status. And just to verify that if you have a client that's applying for an SIV, they need to receive that and then file that form I-485, which is the adjustment of status form. That form needs to be what is pending in order for USCIS to complete their own internal review and see if they would like to provide an extension of parole. And then our next question we were hoping would be answered live. It says, Kristen, for those with pending AOS/asylum, how do we find out if their parole will be or has been considered? I believe you answered that, but I'll invite you to jump back on just to clarify.
Sorry, is that for Kristen or?
I'll jump in. Okay. Yes, just to clarify that. They do not need to apply for re-parole at this time, and USCIS recommends that they do not. However, once they have been considered for re-parole or for extension of their parole status, USCIS will send them a form I-797C to their last address of record. We do not know yet whether they will also send it to the attorney of record on the pending asylum or adjustment of status cases. We hope so, but that is the process that USCIS has laid out right now. They will also not get an EAD card. They will need to get, it will just be automatically extended, and their extension notice should say that work authorization has been extended. The reason why is that Afghans who have parole are able to work without an EAD. It's related to their parole status, so they don't need the new card. If they want a new card, then they can file for an I-765 for a new physical card. We don't know if these notices will show up on their online accounts. We don't know how they're going to be tied to the asylum or applications, and of course advanced or adjustment of status cases are not usually online, so it would be a paper notice in that case. Another way that USCIS has indicated that people will find out if their parole extension has been considered is that they should check their I-94 status on the CBP website, and that will indicate the new period of parole.
Thank you, Kristen. And just for everyone's reference, the CBP website is linked in the chat. Our next live question we have, I know people who applied for green card, but their case is still pending with USCIS. As it was mentioned, they better not apply for re-parole, but the question is that their driver's license was issued based on their employment authorization card's date. What do they need to do if they don't hear back from USCIS?
Kristen, I'll let you take that one as well, if you can. Oh, you're on mute.
It is my understanding that they should be issued the extension notice before their current period of parole expires. And that extension notice can be taken to their local DMV or whoever issues the driver's license in the state to show that their status has been extended, and they should be able to get the new driver's license based on that. If they do have problems with that, that's the instance where we would recommend that they ask for a new C11 EAD, a physical copy, by filing an I-765. Because those are being adjudicated so quickly, they'll be able to get one hopefully within a matter of weeks, and update their driver's license with that information.
Thank you. We did have a question. Why are some I-131 re-parole applications being rejected for lack of fee when no fee is required? Kristen or Michelle, would you be able to just review those steps of what specifically needs to be checked off, probably on the paper filing that would ensure that no fee is required?
Sure, I can take that part. As we mentioned earlier, there's specific boxes you have to check in order to make sure that it's processed as a free re-parole application. And those things are, on the online application, you have to choose, I'm outside the United States and I'm applying for advanced parole. You have to check no to do I want expedited or expedited processing. And you have to click, yes, I'm applying for re-parole. On the paper application, this is a little bit trickier because those last two are not on the application. You will still choose, I'm applying for advanced parole and I'm outside the United States, but you don't have the option to request re-parole. So instead, at the very top, you will write re-parole in large font, highlight it. If you have a cover letter, I suggest putting it on there too, as many times as you can. Just note that it's for re-parole. That way it should be processed correctly. That's what I find has been the most common reason for them rejecting for no fee, is just that the wrong box has been checked.
And another thing to consider, unlike many immigration benefits and applications, there is no fee. So if it's been rejected, it can't hurt to just reapply.
That's a great point, Michelle. And just something while we're talking about the form that I'd like to mention is it's been mentioned by USCIS a few times that they're rejecting forms that do not have OAR or PAR as the class of admission. And that's something that was happening a lot with paper forms. So if you are filing via paper, making sure to write re-parole, making sure to check those boxes, and making sure that you're listing OAR or PAR as the class of parole or the class of admission. And of course, ensuring your client has that. Someone asked the difference between an I-131 and an I-765. It was answered, but just in case, the I-765 is the application for work authorization. That's not what we're talking about today. Today, we're focusing on the I-131, which is the application for a travel document that we've discussed is also being used for re-parole. Is there a deadline to fill out the application? We've mentioned that, July 31st, 2024, but definitely apply before, well before your client's current parole ends. Getting to, here we go. There is a question. Michelle, if you'd like to take it, I am a volunteer, non-lawyer. Am I a preparer and need to send a preparer statement of some sort?
Yes, you are a preparer and you need to fill out that section of the form online and on paper. If you are a volunteer lawyer, keep in mind that you would have to file a G28 as well, or the organization you're working for, check with them because they would have to, lawyers are required to file G28s if they're preparing the form. Lawyers and accredited reps.
Thank you, Michelle. And like we showed on that one screen online, the preparer statement is a separate document you print, fill out, scan back in. And on the paper application, it's the very last section. We talked about creating emails for clients that don't have emails, especially children. There is, if you just type in Google how to create a Gmail account, or I did place the link in response to that question, you can create a new email account for a person, or a parent can create one on behalf of their child for the purposes of filing for re-parole. Here's another live question. What will be the maximum time for pending cases? That's the question that clients are asking the most about, is how long will this be pending?
I can take part of that, and I don't know if Kristen, if you want to add anything. Unfortunately, we still don't have any clear communication regarding processing times overall. They have put out something called New Progress, where applications can check on the status of their parole. And the last I heard a few days ago is that it's currently showing 3 months for re-parole applications. We have heard that officers are still reviewing applications in the order that they are received. And so they can see when the parole expires. We're still not sure if they are prioritizing based on when the parole expires. And it has not been confirmed. Another ongoing question is that it has not been confirmed that the re-parole extension period of 2 years will start from the date the current parole ends, as opposed to the date the application is approved. So there's no guidance on that yet. And unfortunately, I think that maybe this is Zainab who had asked, this is a question almost universally, every client asks, how long is it going to take? And the best possible answer is to say, I don't know. Once we file an application as preparers and attorneys, it's out of our control how long it takes to apply. I just keep checking your account to see if there's any progress. But it can be difficult to manage clients in that way, but it's really important to manage their expectations properly and not, even if you feel a little bit pressured to give a time period, to not do that, because we honestly don't know. And if it takes longer than you suggested or guessed, they might hold you to that, or they're going to be expecting that.
And just to add to that, USCIS has indicated that they would start this process in July. So here we are at July, is it 19th now? 19th. Sorry, here we are at July 19th, and we haven't received any adjudications yet that I'm aware of. And people started submitting on June 8th. So we know that it's taking at least 6 weeks at this point for people to receive a response.
Good point, Kristen. Thank you. I apologize for jumping back, everyone. I'm having some trouble keeping track of the different tabs on the Q&A, but when I was talking about creating a Gmail account, someone mentioned that Google doesn't allow you to create multiple accounts. As long as you create the account, create the Gmail account, you want to be signed out of your own Gmail account. You want it to be like you're a completely new user. Create the account that way, write down the email address, write down the password, log out, then do the whole process again for the next person. So as long as you log out, you should be able to make new accounts. That's what I did. Personal story real quick. I made accounts for each of my children to try to save pictures too. I failed, but I was able to have my own personal account, my work account, one child's account, my other child's account. So as long as you make sure to sign out and then create a new email address for a new person, it should work. You can always come to our office hours or submit a technical assistance request if that's something you need additional assistance with. All right, the next question that we will be answering live is, what if clients are not aware of what they have applied for before?
Kristen, would you like to take that one?
That is a good question. They may not be aware of what they have applied for before. Hopefully, whoever helped them apply for it gave them copies of their application and has made sure that they're receiving receipt notices. But we know that's not a perfect process. One thing that they can do is that you could help them call USCIS at the customer service line to see if they have any, just giving their name and their A number from their EAD to see if they have any applications pending. One thing you can do is ask them to bring in any documents that they have received. They may not understand what the document is, but you can look through it and figure out what it is. And then, if all else fails and that they entered as an OAW or an OAR or PAR parolee, then you can go ahead and submit a re-parole application to hedge your bets. There's nothing saying if you have a pending asylum or a pending adjustment of status application that you can't file for re-parole. You can file for re-parole. It's just that USCIS suggests that you not overwhelm the system by filing for re-parole. And that they will review those applications. And if they see an asylum application pending, they've indicated that they may go ahead and just extend their current parole status and close out or administratively close the I-131 for the re-parole. Obviously, we don't know this quite yet, but that's what they have indicated may happen in those situations.
And I would just add, it'd be helpful to get an idea if they've filed anything before, by asking them questions like, have you ever been to someone who was going to help you file for an immigration benefit? and then ask them a few questions about what they were asked, what the questions they were asked. Did they notice if the person preparing it was doing it on the computer, or did they do it on a paper that they were asked to sign? But asking them if some scenario like that happened where they were told they would be getting a work permit, maybe asking them the types of questions that they would get for a re-parole application or an asylum application, which is longer. You could describe to them it's longer, and you're being asked if you have a fear of returning to your country based on your religion, for example, a political opinion. You can get an idea by sort of probing those types of questions. You might not get a full answer, but it might be a good starting off point to ask them general questions like that.
Thank you so much. I'm scrolling through our Q&As for questions we said we'd answer live or that do not yet have answers. Will the follow-up information, etc., go to the email attached to that individual, i.e. children, or to the parent's email? So will anyone get email correspondence from USCIS? Kristen?
I find that no, you don't get any sort of email correspondence from USCIS. Usually it will appear only in the My USCIS account or be sent to them by mail, or both. There are instances where you can sign up for notifications, and you'll get a notification that correspondence has been sent, and then you'll have to log into My USCIS or wait for the mail to come.
Thank you. And we have a question that's in a couple pieces, so please bear with me, everyone. I greatly apologize. So if the client's work authorization is expiring, which form should they complete first? And it looks like the person already filed for asylum adjustment, and their work authorization is expiring in the middle of September. So what advice might you have for someone in that situation?
Kristen?
If they have already received asylum, their asylum approval should contain their work authorization. And that means that they already have a status. So they don't have to file for re-parole in this case. In this case, if they're just waiting for their asylum adjustment or asylum adjustment of status application to be approved, then they're not applying for a new C11 EAD.
Thank you so much. And then someone, I'm not sure if we can answer this, so I'm going to throw it out to your expertise. Employers aren't accepting clients without employment authorization documents. How would you suggest they move forward?
I'm sorry, Ashley, was there anything, was that just the extent of the question? They don't have employment authorization documents at all from their initial parole period? Am I understanding that correctly?
I'm not sure. It just says employers aren't accepting clients without employment authorization documents. How would you suggest they move forward? So if there's a parolee without an employment authorization document right now, or without, if there's a lapse in time, what would we suggest?
Kristen, I'm sorry, you look like you're about to. I can answer part of it and you can jump in. In this situation, Afghan parolees, they call it being authorized incident to status. Is that the right terminology? So you don't actually need a physical employment authorization card. The problem is there's a bit of a disconnect with quite a few employers who don't understand that concept or are concerned about accepting that without an actual card. As we understand, USCIS is working on a policy letter that you would be able to take to your employer that outlines that a bit more clearly, and that there are updating the employment authorization handbook, or the revised handbook for employers when they're hiring non-citizens. But I don't know what else, Kristen, if you have any other advice in that situation.
I am looking for the information, but there is a way to actually work through the Department of Labor to send information to the employer that they have to accept the extension letter as proof of employment incidences status, or the policy letter whenever that comes out. The other possibility is that if somebody has been granted an extension of their parole status, then they can still file a new I-765 to get a new physical card if it comes down to that. Okay, Jenny.
Yeah, sorry.
Department of Justice. Go ahead, Jenny.
From VECINA, just wanted to share with everyone that when you do have employers that are refusing to accept documents that applicants or that your clients are legally entitled to use, because that definitely happens, that employers say, like, I don't care what you tell me, I don't care what your letter says, I want X document, you have to give me that. There is actually a special section at the Department of Justice called it's now called the Immigrant and Employee Rights section. And I can we can share out the link with all of you, but they have a lot of really helpful information on there, including flyers for employers. And sometimes just giving the employer something from the Department of Justice might, make them sort of perk up their ears and listen. And also sometimes the DOJ folks can actually get involved and talk to the employers and inform them about what the law is and what they're and what they need to do. And they also might be a great resource for your organization, for you to be able to talk to them. So I would encourage everyone to take a look at their website, take a look at their materials, see what they have, and potentially reach out to them if needed. Because I think this is going to be, given the sort of weirdness here where USCIS is giving people this I-797C and telling them to use it with an expired EAD, that's going to lead to confusion. And so that's hopefully the folks at DOJ may be able to be helpful about that.
Okay, thank you. Thank you. It looks like we have a raised hand. If you could please put your question in the question and answer section for right now, we would greatly appreciate that. Kristen and Michelle, it looks like our next question. For example, we have already filed the I-765 for work authorization and it has been rejected. Do you think they will still receive an EAD or should they reapply? My apologies, I'm not sure which other question that might be in reference to, but if there was a client that filed an I-765 and was rejected, can they still apply for re-parole if they are eligible? What do we think?
So without knowing what the original question was, I'm assuming they did apply for re-parole. And well, there's two scenarios. They had a previous employment authorization document, and then they applied for re-parole, and they applied again for an employment authorization document, and that was rejected. Or they might be talking about the first time they applied for employment authorization. I think those are the two scenarios. So Kristen, what do you think? I guess either way, I wouldn't let it keep you from applying for re-parole. And if it's incident to your application for re-parole, you wouldn't have got, I guess you wouldn't have gotten a rejection yet for that I-765. And if you have, it'd be important to see if you filled out the application correctly.
Thank you, Michelle. Did you have anything to add, Kristen?
No, I don't have anything to add.
Okay, perfect. Kristen, I do have a question for you, our next one. Regarding I-131 military PIP, why is there not an application type on the form rather than having to write that option in the application type section, living in military town?
I think this question is probably best answered if you come to our office hours or if you submit a technical assistance request, just because it's kind of outside the bounds of this application or this webinar. And I mean, it is an important thing to know because some people are eligible for parole in place, and this is very important in military towns. We would like to answer it, but we would recommend that you either come to our office hours, which we'll list later on in the webinar, or submit a technical assistance request.
Thank you, Kristen. And then I think we answered that when we discussed when Jenny hopped on and helped us answer. This question, is it ever too early to apply for re-parole? Kristen, do you have any thoughts?
I don't think it's ever too early to apply for re-parole. I would recommend that if you have somebody who has one of the later parole entries, that you prioritize your people who have a parole status that expires sooner. Another reason why you might want to wait closer to that July of 2024 deadline is that in theory gives a person that much more time in parole status if you need it. But there's no reason why somebody with a later parole expiration date couldn't apply now. And it may be that USCIS will also see the expiration date and push those adjudications to later as well.
And Ashley, can I just, there's one question that I'm not sure we've gotten to, and it seems to be something that several people are asking about.
Absolutely. I'm just going in order, but yeah, you can jump on.
Sorry. I'm sorry. Okay. Well, what happens if we have filed re-parole for Afghans with pending asylum? That some clients are panicking because they think it was a mistake, I guess, to file for re-parole. And I guess the simple answer is I think that scenario is not going to hurt them. So I don't think in that scenario, clients should be panicking. It's not recommended in that situation, but if they do it, I don't think it's going to hurt either one of their applications.
Yeah, and I'd just like to add that, keep in mind these are two separate processes. So having a pending asylum application or having a pending adjustment application is not going to be harmed if you file re-parole, and vice versa. Re-parole is not necessarily going to be harmed if you have these pending applications. USCIS has not indicated exactly what they will do in this situation. It sounds like their inclination is to go ahead and do the extension of the current parole period, and then they would admin close the I-131 for re-parole. We don't know that yet. I will say that, as a practitioner, I do have clients where I feel like even though they have a pending asylum application, it was important to also file for re-parole. So I did that. And it's kind of, you have to do what is best for your client and take into account, are you being a zealous advocate for your client and making sure that you're not closing off a potential form of relief. So it's just kind of a case-by-case basis. Review your client's application, or you review your client's situation. And if you feel like re-parole is also necessary on top of their asylum or adjustment application, it's not going to harm those applications. But just to reiterate, USCIS would prefer that they not file the applications just so they don't have too many applications to consider. That's just an addendum, but keep in mind your client's situation and do what's best for your client.
Yeah, and I would add to that, Kristen, if somebody's initial parole period expires before they apply for re-parole, they won't be able to apply, they won't be able to apply for re-parole. And they will be, they won't have authorized stay unless they have a separate immigration benefit pending. So, these are difficult things to balance. But if you're really trying to help someone whose parole is about to expire, it's important to keep that in mind. If it expires before, even while the application is pending, they'll be here without authorized stay.
Thank you. And just so everyone's aware, if you typed in a question, I promise you we are answering it. I'm just going straight down the row so that nobody gets missed. Our next question, and it looks like, Kristen, you might have started to answer this. Do parents need the preparer statement while applying for their children?
I would generally say it depends. If the child is under the age of 14, the parent has to fill out and sign the application. Children under the age of 14 can't prepare their own immigration documents. So in that case, I would say the parent is not the preparer. For children over the 14, if the parents fill out the application and just have the child sign it, possibly. I would say in any case where a third party outside the family, like if a parent brings their 8-year-old child or brings their 15-year-old child to your office and you're helping them fill out the applications, even though the parent is really doing all the information, giving you all the information, you're the preparer because you're the one physically typing in the information. It's not possible. I don't think it's possible to do two preparer statements in the online application. I think you're limited to one. So it'd be whoever is actually filling out the application would fill it there. Same on the paper application, you only have the chance to put in one person's information. So in that case, I would say, even if the parent is giving you the information, it should be your name there, not the parent's information. That being said, if an Afghan parent is doing this process on their own, they can fill out the preparer's information. It's not going to hurt the application, but they could also leave it blank. I don't think that would harm the application in any way.
Thank you. Back over here. If either re-parole or TPS have been applied for, is it true that deportation proceedings would not start? Clients are protected, right? What are your thoughts on that, Michelle?
There's a pending TPS application and a pending re-parole application. That's the question.
If either, so if there's a re-parole and or a TPS application, if those statuses have been applied for, is it true that deportation proceedings would not start and clients would be protected from that based on those applications being submitted?
Yeah, I think it's going to depend. I'll start with the TPS application. If it's just pending, I mean, there's just kind of too many scenarios for me to think about. TPS can be for any Afghan national, regardless of when if they arrived within the right period, so they'd have to be eligible. It doesn't mean that they're necessarily going to be approved just because they filed the application. They have to have the right entry date in order to qualify for TPS. So I would say in that case, I don't think there's a guarantee that they wouldn't be placed in removal proceedings. And then for the re-parole application, again, you'd have to look at the expiration date of the initial parole period. I think in theory, if the parole period has expired, they don't have authorized stay, and so they could be placed in removal proceedings. I mean, one thing to remind, I'm not sure what context this question is being asked in. I know individuals are always concerned with maintaining authorized stay without any lapse. So if they are eligible for an immigration benefit, they should apply for it as soon as possible. But just to think about, depending on where they are, what state they're in, just to remember that getting placed in removal proceedings doesn't happen if you're just walking down the street, living your life here in the United States. Usually it happens when you're apprehended at the border, if you've been arrested for a criminal offense, if you've applied for a benefit and it's been denied. So, you know, to try to ease their concern a little bit, you might explain how the law works here in the United States regarding there's no the requirement to carry identity documents. That's not required. So that's something to keep in mind. But it's just going to depend a bit on each person's situation. So I wouldn't say that in every scenario, having a pending TPS or re-parole application, you'll be protected from being placed in removal proceedings. But you might just want to think about what the likelihood is that that's going to even happen. And Kristen, I'm sure you have something to add.
You know, this is one situation, if you have more detailed questions about this, come to our office hours and we're happy to discuss it more in person, and we can get more detailed information, like if you have specific questions or if you have a specific client where this has happened to. But anybody who is not in a lawful status can be put into removal proceedings. But if they have a benefit available to them, oftentimes the proceedings can be administratively closed by working with the USCIS or ICE attorney to do that. And I'll just leave it at that, but we can answer more. If you have more detailed questions, please come to our office hours. We're happy to discuss it there.
Thank you, ladies. And just to follow up on that, yes, definitely about office hours. Someone is asking about filing both TPS and re-parole. So just want to clarify for everyone on the call, are clients able to file for both TPS and re-parole, or re-parole and another form of relief?
The general answer is yes. You can have pending applications for multiple immigration benefits. That's not a problem. You can have TPS pending, asylum pending, adjustment pending, and whichever gets adjudicated first, that's the way it happens. So it shouldn't harm you in any way to have multiple applications pending.
Thank you, Michelle. Okay, and then I think that's more of a technical question. Here we go. Do unaccompanied Afghan minors continue to not have a limit to parole status and do not have to apply for re-parole, or do they have a different time frame?
Kristen, I'm going to ask you if you know the answer to that.
I'm not an expert in the unaccompanied minors, so that's something I would have to research. So in that case, if you have specific questions, submit a technical assistance request and we can look into that in more detail for you.
Thank you. There's some questions about the Gmail account, so I am going to skim through those while I ask you our next one. What happens if parole expires before you apply for re-parole?
I'm sorry, I didn't catch that question.
My apologies. What happens? I moved the question. What happens if your parole expires before you receive re-parole?
I think I answered that question already. I don't know if Kristen had anything to add. The guidance we have so far is, well, go ahead, Kristen.
No, go ahead with the guidance we have so far. Finish your thought.
The guidance we have so far is if your re-parole expires while your re-parole application, sorry, if your initial parole period expires while your re-parole application is pending, you will be out of status and not under authorized stay.
Right, and USCIS has confirmed that in other presentations they've given that even if you filed for re-parole before your period of authorized stay expires and they have not adjudicated yet, you will be out of status. It's important to keep in mind the rules about unlawful presence in this situation, but that they still may be eligible for future benefits. We'd have to look at that on a case-by-case basis to really determine what is best for that client. So I would say that, if you do have a client in that situation, come August, September, when all these parole periods start to expire, we'd be happy to answer and help figure out a way to protect your client's interests if you come to our office hours or if you submit a TA request.
And yeah, just to reiterate, apply as soon as possible in almost every situation, given that we don't know what the processing times are.
Absolutely. Thank you, ladies. It looks like we have answered all of the questions. So I am going to just give everybody a minute. If you feel like your question wasn't answered, or if unfortunately we did miss it somehow, please type it back in the chat. There was one that popped up right as I said that. Do people with valid TPS need to apply for re-parole? Can one individual have both TPS and parole status at the same time? I feel like we've answered that, but I will let you ladies speak to that just to make sure it's clear.
If the only status they have is TPS, I encourage them to apply for re-parole. TPS currently for Afghans is only authorized through November. It has not been reauthorized yet, so we don't know what's going to happen to people with TPS from Afghanistan. So I would encourage that if they are eligible for re-parole, they have that OAR, PAR class of admission, file for re-parole. That's going to be the best thing for your client.
Agreed.
Thank you, Kristen. And then we have two questions that just popped up. What about OAW? Can people with OAW class of admission apply for re-parole?
Yes, OAR and OAW are synonyms, basically. The program initially started as Operation Allies Welcome, or Operation Allies Refuge, and then changed to Operation Allies Welcome, or maybe vice versa. But they refer to the same program as admitting Afghans during the evacuation from Afghanistan in 2021. You can use either one.
Yeah, I think that's pretty clear. And I want to just jump back to the previous question about TPS. You can have both pending. It doesn't harm in any way. And remember that I don't believe TPS grants eligibility for benefits.
Yeah, that's correct. I would keep in mind that if your client does need public benefits, they will need a status that allows them access to public benefits, and that's both federal and state public benefits. Usually, I would check with your local state immigrant benefits office to make sure who is eligible for what. But TPS generally does not grant access to public benefits versus having a parole status, whether extended or re-parole, does or should.
Thank you. So there is a question, can clients apply for travel documents when their asylum case is pending? So if they truly need to travel and that's dealing with their asylum case, that is definitely a question for our office hours or a TA request. If it's confusing, because it absolutely is, that this Form I-131 for Re-Parole talks about a travel document, the I-131 for Re-Parole would not affect the asylum case because you're not actually applying for a travel document, you're applying for Re-Parole. But as we've stated a few times, if you have a pending asylum case, then USCIS has said you do not need to apply for Re-Parole, and they would do that internal process. So I hope that helps answer that question. There's some issues with Gmail questions coming through, so I am going to be researching that a bit more, and I believe I'll be able to respond to all attendees. So if you're someone that needs some help with that, be on the lookout for that following this webinar in the next few days. I apologize, questions pop up and leave. Can a parolee who receives TPS lose their benefits? I believe we covered that. Am I correct, ladies? I think so. Okay.
I would say yes.
Okay. Lose their benefits if TPS. Okay, that ran away. Do you have an estimate on when the recording will be posted? I believe the recording will be sent within 24 hours, and then in the following days, everything will get posted online. So as long as you registered and submitted a good email address for you, you should get that recording shortly. All right, we are slowly coming to the end of our time. I will wait a few more seconds to see if any other questions pop through. While we do that, can we get our PowerPoint slides back up, please?
Okay, so we're nearing the end of the webinar, and just to go back to the objectives that we stated at the beginning of the presentation, we hope that you are now more comfortable in determining who qualifies for Re-Parole, Afghan Re-Parole, why it's important, and that you are able to address some of the common concerns among preparers and their clients in the community.
So now we know we asked this question at the beginning. We'd like to ask it now, hoping that some answers may be shifted. After participating in this webinar and our discussions, how confident do you feel preparing and filing an Afghan Re-Parole application? Our average was about a 2.7 previously. It's looking better now. Again, you can use your camera to scan the QR code or type in slido.com and enter that code. And I know I just said like, yay for having a high number, but it's okay if you're still a 1, 2, or 3. Maybe letting this sink in will help. And again, we're going to share some resources and hopefully those will help you as well.
And for somebody who's still feeling uncomfortable, feel free to come to our office hours every Thursday, and we're happy to walk you through the process further.
Yes, absolutely. All right, so before we get into those resources I just mentioned, please take a moment to scan the QR code on the screen. I will also get the link in the chat in just a moment. This survey helps us to continue helping you and helps us plan for future trainings. So it's 3 minutes long, takes 30 seconds. So I will give you a moment to do that now. Okay, so hopefully you've got that up. You can complete it later. Here are our recommended resources. So I will share links in the chat in one moment. We've got some USCIS information to share with you, what they've put out about this process and online applications or online accounts and applications. Then we also mentioned the VECINA Re-Parole course. That's where you can access a step-by-step filing in video form and an annotated paper form. We also will have a downloadable resource coming out through Switchboard soon that will be a paper version of that, essentially walking you through the process. And then we have our weekly office hours that we've mentioned. So every Thursday at 2 p.m. Eastern, you can use the link I will put in the chat in one moment, and it is already in there from earlier. You can just log in and come in to ask your questions. We will do our best to get to everyone, and it's been a really nice conversation. We can talk about re-parole, we can talk about asylum, SIV, case-specific questions, whatever you need to keep assisting Afghan parolees. And then we also have technical assistance requests, which we'll talk about a little bit more in a slide. But if you have a request for your agency, if you have a request for a specific case information, you can fill out a technical assistance request. And I did forget to mention, it is on the slide, that for our office hours, they are only for legal providers, so only for attorneys and accredited representatives at ORR funded agencies. So unfortunately, we can't help people filing on their own or people who are not a legal professional. Oh, I apologize. The link didn't copy. That's my fault. I'm so sorry, everyone. I'm getting those in their chat for you now.
Thank you so much, Ashley. And thank you so much to all of our speakers from VECINA. This was a wealth of information that you have shared with us today. And with that, we're going to close out our webinar. We're going to say stay connected with Switchboard at rescue.org. And you can join us on social media. Our handle is Switchboard TA, or submit a TA request by emailing us directly or visiting our website for our whole wealth of resources, www.switchboardta.org. Thank you so much to all folks who joined us today, and we hope to see you on another Switchboard webinar soon.